in November of 2024, on a Wednesday morning in a paneled mediation room on the 8th floor of an office building on Federal Street in Boston. A 78-year-old retired attorney named Howard Mendelsohn opened a leather briefcase and removed a single document. The document was 47 pages long. It was bound at the top with a green ACO fastener. It had been printed on cotton rag paper in October of 2002. Signed at the bottom of every page by 2 parties and 1 notary, and stored in a fireproof cabinet in Howard's office in Newton, Massachusetts, for 22 years and 3 weeks. Across the table from Howard sat a 47-year-old attorney named Philip Whitfield Crane, Jr., whose late father had drafted that document in October of 2002. Beside Philip sat my husband, Theodore Whitfield IV, who I had married 5 days after the document was signed. Beside me sat my own attorney, Daniela Reyes, who had spent the previous 7 months locating Howard, persuading him to come out of semi-retirement and walking him through what we needed him to do. Howard set the document on the polished cherry table. He cleared his throat. He looked at me, gently, the way a great uncle might look at a niece he had not seen in many years. Then he addressed Philip Whitfield Crane, Jr., who was the son of the man Howard had outmaneuvered when Philip was 15 years old. Howard said, "Mr. Whitfield Crane, I am consulting counsel of record on this prenuptial agreement, as reflected in the footnote on page 47. I was retained in this matter by Mrs. Whitfield's grandfather, the late William Robert Carter of Hartford, Connecticut, in August of 2002, exclusively to review the proposed agreement on behalf of his granddaughter and to insert any protective provisions I considered prudent. 2 such provisions, Clause 14 and Clause 31, were accepted into the executed agreement by your firm's associate, Mr. Jeffrey Tatum, in a markup exchange dated October 8, 2002. Mr. Tatum's acceptance was confirmed in writing by your father in a cover letter dated October 11, 2002. I have the cover letter in my file. I should like to read clauses 14 and 31 into the record now." Philip Whitfield Crane, Jr. went very still. He had not been told there were any disputed clauses. He had not been told there was consulting counsel. He had certainly not been told there were active provisions that no member of his firm had ever flagged in 22 years. I sat in the chair Daniela had picked for me. I did not need to speak. Howard read, "I want you to understand the world I walked into in October of 2002, because the prenup I signed cannot be understood outside of it. I was 25 years old. I had grown up in West Hartford, Connecticut, in a brick colonial my parents had bought in 1981, with a 30-year mortgage they paid off 2 months before my mother died. I had gone to UVM in Burlington, Vermont, on a partial scholarship and graduated in 1999 with a degree in art history. I had moved to New York that summer and worked as a curatorial assistant at the Whitney Museum until I met Theodore Whitfield IV at a gallery opening in Chelsea in March of 2001. He was 30. He had gone to Hotchkiss and Yale. His family had been in Greenwich since the 1880s. We were engaged in May of 2002, 6 weeks after he proposed at a restaurant on Madison Avenue with a pave diamond from his grandmother's collection, which I had not yet learned was a substitute for the kind of ring that comes with a receipt. The wedding was set for Saturday, October 12, 2002, at Christ Church, Greenwich on Park Avenue, with the reception at the Greenwich Country Club on Round Hill Road. The guest list was 411 people, of whom I had personally invited 18. On Friday, October 7, 2002, 5 days before the wedding, Teddy's mother, Margaret Whitfield, called me at 4 Sungo in the afternoon. She told me in her quiet voice that the family attorney needed me to come out to Greenwich the following morning to sign some routine paperwork. She used the phrase routine paperwork. She said the documents would be ready at the law office on Putnam Avenue at 10 o'clock. She said I could be back in New York by lunch. I told my own attorney, a friend of my father's in Hartford named Edward Burgess, about the meeting. Edward said he could not get to Greenwich on a Saturday on 5 days' notice, but he would review whatever I brought back. He told me I should read the document carefully before signing and ask for a copy to take home. I told him I would. I did not. I drove out to Greenwich on Saturday morning in the used 1998 Honda Civic I had bought in Burlington my senior year. Teddy was in Greenwich already. He was scheduled to be at the Belle Haven Club for a golf outing with his groomsmen. He told me he would meet me at his parents' house on North Street afterward. The law office on Putnam Avenue was the firm of Whitfield, Crane, and Halsey, which Teddy's great-grandfather had co-founded in 1928. The senior partner who met me in the conference room was Philip Whitfield Crane, Sr., Teddy's second cousin once removed, and the firm's managing partner since 1989. He was 64. He had silver hair and a light gray suit and a slim leather portfolio. He shook my hand and called me Ellen. He sat me down at the conference table and slid a stack of paper across to me. The document was 47 pages long, cotton rag paper, bound at the top with a green ACO fastener. The cover page read, "Prenuptial Agreement between Theodore Whitfy and Ellen Marie Carter, executed October 8, 2002, Philip Whitfield Crane, Sr." Explained the document to me in approximately 4 minutes, in the brisk voice of a man who has explained the same document to 12 other young brides in his career. He said it was a routine prenuptial structure customary in families of, in his phrase, certain longevity. He said it provided that each party would retain separate ownership of any assets brought into the marriage and any inheritances received during the marriage. He said it provided for a limited divorce settlement in the event of dissolution after a marriage of less than 10 years, increasing modestly thereafter, capped at $400,000 in cash, plus the marital condominium in New York. He said it was, in his phrase, very fair. I asked him if I could take a copy home to my attorney. He smiled the way a man smiles. When he has been asked a question, he has been asked before. He said the document was being executed in original form today, with notarization, and that he was happy to provide a copy after execution. He suggested gently that delaying execution at this point would be socially awkward, given that the wedding was 5 days away. I should have stood up. I should have said, "Then we will have to be socially awkward." I was 25 years old. I had been raised to be polite. I signed all 47 pages with a fountain pen Philip Whitfield Crane Sr. handed to me. I dated the last page October 8, 2002. The notary, a woman named Patricia Adair, stamped each signature. The whole thing took 11 minutes. I drove back to New York with no copy of the document and married Theodore Whitfield IV the following Saturday at Christ Church, Greenwich, at 4 o'clock in the afternoon. What I did not know, what I would not learn for 22 years, was that my grandfather, William Robert Carter, had been told about the meeting on October 7, 2002, by my mother, who had heard about it from me by the night before. My grandfather had picked up his telephone on Tuesday morning, October 8, 2002, at 7:14 a.m., and had called a Boston attorney named Howard Mendelsohn, with whom he had served on the board of a manufacturing trade association in the 1980s. He had asked Howard a single question. The question was, "Howard, can you get yourself into a markup exchange on a Greenwich prenup by close of business today?" Howard had said, "Bill, I can. What do you want in it?" I do not intend to spend long on the marriage itself, because the marriage was, for most of it, ordinary. We bought a house at 84 Hendry Avenue in Riverside in 2004. Our son, William Whitfield V, was born in November 2005. Our daughter, Charlotte Whitfield, was born in March 2008, 6 months before Lehman fell. We weathered the financial crisis with the cushion every Greenwich family with a multi-generational trust weathered it with, which is to say, without consequence. Teddy worked at his father's asset management firm in Stamford. I curated a small collection at the Bruce Museum on weekends and, after Charlotte was born, taught a textile arts class on Tuesday mornings at the Greenwich Adult Education Center. We had Sunday dinner at Teddy's parents' house on North Street most weeks. We summered at his family's cottage on Fisher's Island. We sent the children to Brunswick and Greenwich Academy. We voted at the same polling station on Sound Beach Avenue. We were photographed in the Greenwich Time on at least 4 occasions, twice at fundraisers for the Greenwich Land Trust and twice at the spring auction for the Greenwich Historical Society. Our marriage looked from the outside exactly like every other marriage in our pew at Christ Church. What I will tell you about it from the inside is one thing. From about 2017 onward, Teddy began to grow restless in a way I could feel before I could name. He stopped reading at night. He started traveling to client meetings he had not previously traveled to. He bought a new car every 2 years instead of every 5. He took up cycling and joined a club that rode out of Riverside at 5:30 a.m. on Saturdays. He began, on certain Sundays, to look at his phone in a way that suggested a private correspondence I was not part of. I did not ask. I had been raised in a marriage where my own mother had not asked, and where the not asking had been, in the end, a kind of dignity. Our 20th anniversary was on October 12, 2022. We marked it with a dinner at Lescale on the harbor in Greenwich. Teddy gave me a Smithson notebook and a pair of vintage earrings from a jewelry store on Greenwich Avenue. He told me he loved me. I told him I loved him. The bill was $384,000 plus tip. We drove home at 10 o'clock at night and watched the 10:30 news. Neither of us said the word 20 out loud after we left the restaurant. I remember thinking, distinctly, in the car on the way home, that the next anniversary I would be paying close attention to was not the 25th, which was 3 years away, but the one we had just passed. I met Camille Esposito Reeves once at the spring 2023 opening of a contemporary gallery on Greenwich Avenue near Putnam. She was 41. She had black hair cut to her chin, and the kind of confident voice that arrives in a room before its owner does. She owned the gallery. She had been divorced once, from a hedge fund manager who lived in Bellhaven, and she had a 6-year-old son in the Greenwich public schools. Teddy introduced us. He shook her hand for slightly too long. I noted it, the way you note that the carpet has been cleaned recently. I said nothing to him in the car on the way home. By January of 2024, the not saying had become the architecture of the marriage. Teddy had begun missing dinner 2 nights a week, with explanations that were technically true, but emotionally false. He had begun taking phone calls in the garage. He had begun on Saturday mornings to ride alone instead of with the cycling club. I had not gone looking for any of it. Information arrives in a long marriage the way weather arrives. You do not need to forecast it. You only need to notice when it has shifted. On a Tuesday afternoon in late January of 2024, after Teddy had left for work, I sat at the breakfast table on Hendry Avenue with my second cup of coffee and a yellow legal pad. I wrote at the top of the legal pad, "Things I know." I made a list of 14 things. Then I wrote at the top of the next page, "Things I do not know." The first item on the second list was, "Where the original prenuptial agreement is." I did not have a copy. I had never been given a copy. In 22 years, I had not asked for one. On the third item of the list, whether anyone in my family had ever read the document on my behalf. I paused. I remembered, suddenly and with great clarity, that my grandfather had called me 3 days after the wedding from his office in Hartford. He had asked, without preamble, whether I had signed any paperwork in the days before the wedding. I had said yes. I had described the meeting briefly. He had been quiet on the phone for several seconds. Then he had said, "Ellen, if anything ever happens, you call a man named Howard Mendelsohn in Boston. He's in Newton." Howard with a W. You remember that name? I had remembered the name. I had not, in 22 years, had occasion to use it. My grandfather had died in March of 2007 of pancreatic cancer at the age of 83. He had sold Carter Tool and Die, the small precision machining company he had founded in Hartford in 1957, 3 months before his death, for $28 million. On the afternoon of January 30, 2024, I took the phone book down from the kitchen shelf. The actual paper white pages, the last one Greenwich had distributed before they stopped. And I looked up Howard Mendelsohn in the Boston Metro listings. There were 2. One was a dentist in Brookline. The other was an attorney in Newton. The attorney had an office number with a 617 area code. I wrote the number on the legal pad. I did not call it. Not yet. Daniela Reyes is 404, Cuban-American, born in Miami, Tufts undergrad, Harvard Law class of 2005. She is a partner at a 5-attorney boutique on Beacon Street in Boston that handles high net worth matrimonial matters across New England. I was referred to her by my Zama's husband, who is a tax partner at Goodwin Procter, and who told me, when I asked him over Easter brunch in Hartford, that if I was ever going to need a divorce attorney, I should call Daniela Reyes and not anyone in Connecticut. I drove to Boston on Friday, April 12, 2024. I parked at the Boston Common Garage. I walked up Beacon Street to the brownstone, where Daniela's firm has its second-floor office. Daniela met me in the small conference room at the back. She had a yellow legal pad and a glass of water, and the same kind of patient watchfulness Margaret Choi would have, 8 months later and 1,200 miles to the west, in Madison. I told her the story in about 40 minutes, the 2002 meeting, the 47 pages, the fountain pen, the lack of a copy, the marriage, Camille Esposito Reeves on Greenwich Avenue, the list of 14 things I knew. My grandfather's phone call 3 days after the wedding. The name Howard Mendelsohn. Daniela listened. She did not interrupt once. When I was done, she asked me 4 questions. Did I have any documents from October 2002? I did not. Had I ever, in 22 years, asked Teddy or his family for a copy of the prenuptial agreement? I had not. Did Teddy currently know I was contemplating retaining counsel? He did not. Was I prepared, if necessary, to be patient? I said, Daniela, I have been patient since October of 2002. She said, all right, here is what we are going to do. I am going to obtain a copy of the prenuptial agreement before Teddy knows you are looking. There are several paths. One of them runs through the Greenwich probate clerk, where some prenuptial agreements are filed for safekeeping if either party requested it at execution. Another runs through the Whitfield family attorneys themselves, through a discreet inquiry that does not raise an alarm. A third runs through the man your grandfather called. She said, I am going to start with the third path. On Tuesday, April 16, 2024, Daniela Reyes called the office number for Howard Mendelsohn in Newton. The phone was answered on the 4th ring by a woman who identified herself as Mrs. Mendelsohn. She said her husband had retired in 2018, but still came down to the office one morning a week on Wednesdays for what she called housekeeping. She said she would have him call back. Howard Mendelsohn called Daniela Reyes back at 11:42 a.m. on Wednesday, April 17, 2024. The phone call was short. Daniela explained who she was and that she was representing Ellen Marie Carter Whitfield, the granddaughter of the late William Robert Carter of Hartford. There was a long silence on the other end. Then Howard Mendelsohn said, Counselor, I have been waiting for this call for 22 years. He invited Daniela to drive out to Newton that afternoon. I drove with her. We sat at a kitchen table in a 1958 ranch on a quiet street near Newton Center, with Howard Mendelsohn in a cardigan and his wife pouring decaf coffee from a glass carafe. Howard had a thin manila folder in front of him with the words Carter Whitfield, 2002, written on the tab in fountain pen ink that had faded to gray. Howard said, Mrs. Whitfield, your grandfather Bill Carter telephoned me on Tuesday, October 8, 2002, at 7:14 in the morning. He had heard from your mother the night before that you were being asked to sign a prenuptial agreement that day, in Greenwich, with no advance review by independent counsel. He asked me to insert myself into the markup exchange that Tuesday on his behalf, on your behalf, without your knowledge. He asked me to insert any protective language I considered prudent, on the assumption that the marriage might be a long one, and that the Whitfield family attorneys would be focused in their markup on the alimony cap and the trust asset carve-outs. He told me to look for the corners of the document those attorneys would not be looking at, he said. I made the markup. I sent it by fax to the office of Whitfield, Crane and Halsey at 2:48 that afternoon. The associate handling the file at their end, a young man named Jeffrey Tatum. Second year, Yale Law class of 2001, accepted my markup at 4:31 p.m. without escalating to Philip Whitfield Crane Sr. Mr. Tatum, I was told later by mutual friends, had been told to clean up the document by close of business and not to bother the senior partner with minor housekeeping. He treated my markup as housekeeping. Howard tapped the folder with his index finger. He said, "My name appears in a footnote on the bottom of page 47 of the executed agreement." The footnote reads, in its entirety, Consulting Counsel. Howard Mendelsohn, Newton, M.A. The footnote is in 8-point type. In my professional experience, it is overwhelmingly likely that no one at the Whitfield firm has read that footnote in 22 years. He said, "The two clauses I inserted are Clause 14 and Clause 31. Daniela opened the legal pad on her lap and began to write. Howard Mendelsohn is not a flashy attorney. He never has been. He had practiced trusts and estates in Newton, Massachusetts, for 36 years before retiring in 2018, and his entire career had been built on a single principle, which is that the most useful clause in any document is the one nobody notices until they need it. Clause 14 of the prenuptial agreement read, in its essential operative language, the separate property classifications established in Articles 3 through IAC of this agreement shall expire automatically and irrevocably at 11:59 p.m. Local time on the 20th anniversary of the date of marriage of the parties, provided that no petition for dissolution of marriage has been filed by either party in any jurisdiction prior to that hour. Upon such expiration, the parties agree that all assets and income of either party, of whatever nature, acquired or earned at any point during the marriage, and not otherwise classified as separate property by operation of state law, shall be deemed retroactively to constitute community property style marital assets, subject to equitable distribution under the law of the controlling jurisdiction. Howard Mendelsohn explained, at the kitchen table in Newton, why he had drafted the clause. He said, "Mrs. Whitfield, your grandfather's reasoning was very simple. He told me on the phone that morning that he did not object to a prenuptial agreement at the start of a marriage. He said a young man's family is entitled to be cautious, but he said, no marriage that lasts 20 years should be subject to documents the parties signed when they were children. He said, if Theodore Whitfield was still in your marriage on the 21st anniversary, the document had served its purpose. He said, the marriage itself by then was the relevant agreement. He said, the clause activates on October 12, 2022. From that date forward, assuming neither party has filed by 11:59 p.m. On October 11, 2022, the prenuptial agreement is no longer enforceable as a separate property document. It defaults, by its own terms, to whatever the law of the controlling jurisdiction would have applied without it. The controlling jurisdiction was Connecticut. Connecticut is an equitable distribution state, not a community property state, but the practical effect of the sunset language was the same. 22 years of marriage by 2024 would entitle the lower-earning spouse to roughly 1/2 of the marital assets in any divorce proceeding. In the absence of an enforceable prenuptial structure, to the contrary. Daniela did the math at Howard's kitchen table on a piece of yellow paper. The Whitfield family fortune was not held by Teddy individually. It was held by trusts, but the trust distributions Teddy had received during the marriage. What Howard called, in his folder, the inflows, were marital income. Under the post-sunset framework, half of those inflows belonged to me. Clause 31 was the second piece. Its operative language read, "Any party initiating a petition for dissolution of marriage at any point after the 20th anniversary of the date of marriage shall provide to the non-initiating party within 90 days of filing a complete and audited forensic accounting of all distributions, payments, gifts, transfers, and benefits received by the initiating party during the marriage, from any trust, family office, partnership, holding company, or third-party entity in which any member of the initiating party's family has held a beneficial interest. Failure to provide such accounting within the prescribed period shall constitute waiver of any separate property arguments otherwise available to the initiating party under this agreement or under applicable state law." Howard said, "The clause is a discovery accelerant. Without it, in a Connecticut equitable distribution proceeding, the lower-earning spouse can subpoena trust records, but the trustees can fight subpoenas for 2 or 3 years on grounds of privilege, third-party privacy, irrelevance, and so on. Trust litigation in this region typically runs 3 to 4 years and bleeds the lower-earning spouse. Clause 31 puts the disclosure obligation on the higher-earning spouse on a 90-day clock with a waiver penalty for non-compliance. It does not technically force the trustees to disclose. It forces the husband to obtain and disclose the records himself. The trustees almost always comply because the alternative is watching their beneficiary commit a contractual default that costs him his separate property claims entirely." He said, "The two clauses work in tandem. Clause 14 makes the document irrelevant. Clause 31 forces the cards onto the table." Daniela Reyes asked Howard one question. She said, "Mr. Mendelsohn, are you willing to come to Boston in the fall and read these clauses into the record at mediation in front of Philip Whitfield Crane, Jr., who took over his father's practice in 2016 and who almost certainly does not know these clauses exist?" Howard Mendelsohn looked at me across the kitchen table for a moment. His wife was at the counter, refilling the coffee. There was a small needlepoint pillow on the chair beside him that read Newton Center in cross-stitched letters. He said, "Counselor, I have been waiting 22 years to read those clauses. I told Bill Carter on the phone in October of 2002 that I would do it. Bill paid me a flat fee of $4,000 in cash for a single afternoon of work, and he said to me, in the last sentence of that phone call, 'Howard, I am paying you for the day, the reading you do for free if it ever comes to it.'" He smiled gently. He closed the folder. He said, "I will be there." Theodore Whitfield IV filed a petition for dissolution of marriage in the Superior Court of Connecticut, Judicial District of Stamford, Norwalk, on September 17, 2024. He was represented by Philip Whitfield Crane, Jr., who had succeeded his late father as managing partner of Whitfield, Crane, and Halsey in 2016. The petition cited irretrievable breakdown. It included as a sealed exhibit the prenuptial agreement of October 8, 2002. I had been served the day before, in our kitchen on Hendry Avenue, after Charlotte had gone to school. Teddy had handed me an envelope and said, "Ellen, I'm sorry." He had used the word sorry twice. He had told me his attorney had assured him that under the prenup, the financial structure would be straightforward. Limited divorce settlement of $400,000 in cash, the New York condominium, and a customary, modest support payment for Charlotte through the end of her undergraduate education. He had said, in the kitchen on Hendry Avenue, the line that mattered. "Ellen, the prenup is what the prenup is. Philip says it's watertight. Let's try to be civilized about this." I had said, "All right, Teddy." I had not told him about Howard Mendelsohn. I had not told him about the call I had paid for Daniela Reyes to make in April. I had not told him that we had been preparing for 7 months the response that was about to land in his attorney's inbox. Daniela filed her appearance on my behalf in the Stamford Superior Court on September 23, 2024. She filed a motion to transfer venue to a neutral Massachusetts mediation under a forum selection clause that, separately from clauses 14 and 31, Howard Mendelsohn had inserted in 2002 at Bill Carter's suggestion, on the theory that anything material was better adjudicated in a state where neither family had institutional friendships in the local bar. The Whitfield team, who had not flagged that clause either, did not object. Mediation was scheduled for Wednesday, November 6, 2024, in a paneled conference room on the 8th floor of an office building on Federal Street in Boston, before a retired Massachusetts Superior Court justice named Howard Cabot. Justice Cabot is no relation to Howard Mendelsohn. The fact that 2 Howards ran the day was, Daniela later said, statistically unremarkable in a Boston legal proceeding. Howard Mendelsohn read clauses 14 and 31 aloud at 10:47 a.m. on November 6, 2024. Philip Whitfield Crane, Jr. did not interrupt. He listened with the expression of a man who is mentally rereading a 47-page document he had assumed was settled law of his own family. When Howard finished, Philip Whitfield Crane, Jr. asked Justice Cabot for a 15-minute recess. Justice Cabot granted 30. When Philip and Teddy returned to the conference room, Philip's face had the same color Doug Bowers would have 6 months later in Madison. He addressed Justice Cabot. He said, "Your Honor, my client and I would like to acknowledge that the executed prenuptial agreement contains the provisions Mr. Mendelsohn has just read into the record. We are reviewing the operative effect of those provisions. We respectfully request a continuance of 2 weeks to complete the forensic disclosure required under Clause 31 and to submit a revised settlement framework based on the post-sunset analysis." Justice Cabot granted the continuance. We resumed mediation on Wednesday, November 20, 2024, at the same conference table. The forensic disclosure submitted by the Whitfield team, completed by an outside accounting firm in 14 days, ran 312 pages. It documented all distributions and benefits paid to Theodore Whitfield IV during the marriage from the various Whitfield trusts and the Whitfield family office between October 12, 2002 and September 17, 2024. The total was $4,712,800. Under the post-sunset framework, the math was clean. The Greenwich house at 84 Hendry Avenue, assessed value $4.1 million, became a marital asset subject to equitable division. The Boston brownstone the Whitfields had purchased in 2014 as a second home, assessed value $2.8 million, became a marital asset. The 22 years of trust distributions, totaling $4.7 million, were marital income subject to equitable division. The settlement signed at 3:18 p.m. on November 20, 2024, provided me with the Boston brownstone outright, cash and securities of $3.8 million, primary physical custody of Charlotte until her 18th birthday in March of 2026. College tuition for Charlotte and ongoing support payments under a customary Connecticut framework, and a release from any further claim against the Whitfield family trusts. Will, our son, was 19 and at Bowdoin and outside the custody framework. Philip Whitfield Crane, Jr. did not look at me when the agreement was signed. He shook Daniela's hand without making eye contact. He shook Howard Mendelssohn's hand and said, in a voice that was almost too quiet to be heard, "Mr. Mendelssohn, my father had no record of this in his files." Howard Mendelssohn said, without unkindness, "Mr. Whitfield Crane, your father's firm took my markup as housekeeping in 2002. The records are where they were left. I am sorry to have read them aloud to you under these circumstances. I want you to know I held no ill will toward your father, who was a competent attorney. I held a particular affection for the granddaughter of my old friend, Bill Carter. The marriage outlasted its document. The document had a date on it, and the date came. I am writing this in November of 2025 from the second-floor study of the Brownstone on Tremont Street in the South End. The window faces a small courtyard with 3 pear trees. Charlotte is in her senior year at Brunswick and stays with me on alternating weekends and most school holidays. Will is a sophomore at Bowdoin. I see him on the Friday before each Bowdoin home football game. He drives down from Brunswick, Maine, and we have dinner at a small Italian place on Shawmut Avenue, and he tells me about a girl in his dorm I am not yet allowed to know the name of. I opened a small textile arts studio and gallery on Harrison Avenue in May of 2025. It is called Carter Studio, after my grandfather. I exhibit my own quilts and the work of 3 other New England fiber artists. The studio held its opening reception on a Friday night in May. Howard Mendelssohn drove in from Newton and stayed for 45 minutes. He brought a card his late wife had picked out before she died in March of 2025. He did not talk about the document. Theodore Whitfield IV remarried in October of 2025 to Camille Esposito Reeves. The wedding was at the Greenwich Country Club on Round Hill Road. 400 guests, a Saturday afternoon ceremony at Christ Church, Greenwich. I was sent a polite Christmas card from Camille in December of 2025 announcing the marriage and including a small school photograph of her son, who is now 9. I did not respond. There was nothing to respond to. Philip Whitfield Crane, Jr. Retired from active practice in March of 2025, 4 months after the mediation, and now serves on the boards of the Greenwich Land Trust and the Greenwich Hospital Foundation. The Whitfield, Crane, and Halsey firm is now run by his junior partner, a woman named Caroline Tatum, who is the niece of Jeffrey Tatum, the second-year associate who accepted Howard Mendelssohn's markup in 2002 without escalating it. I have been told that the firm has, since November of 2024, instituted a new internal review protocol under which any prenuptial agreement bearing the firm's name is read in full by 2 senior partners before execution. The protocol is, I understand, called the Mendelssohn Review. What my grandfather, Bill Carter, understood in 1957 when he founded a small precision machining shop in Hartford, and in October of 2002 when he picked up his telephone at 7:14 in the morning, is the same thing every quiet builder of small things in the upper Connecticut River Valley has always understood. The instrument cuts on the part of the line that nobody is looking at. The reckoning is in the corner of the document. You set it 22 years before you need it. You pay for the day. The reading, if it ever comes to it, is free.